Yes, Mr Hendrick.
My Lords, can I just mention the question of timing first of all? Lords, I did indicate to my learned friends in the discussions about timing before we started that I thought we needed 5 hours, my Lord. If that was the case, with 2 hours today, 2.5 hours in the morning, that would put us half an hour after the short adjournment tomorrow, which I hope would enable my learned friends to deal with it. It may be that we'll be, in fact, quicker than that. And if I can finish before the short adjournment tomorrow, that's what we'll try and do.
Thank you much.
Lords, we've handed to your Lordship a sort of summary of what our submissions were going to be orally. It's really a sort of agenda, an agenda for this afternoon, just so your Lordships know where we are in my oral submissions. Lords, can I start with saying something about Mrs Baker in the light of my learned friend Mr Nolan's submissions yesterday? Lord, Mrs Baker is dealt with in the judge's judgment below at paragraph 134, so that's core bundle 2, divider 6 at paragraph 130. I said 134, in fact it's a 182. 182. Lord, we just wanted to remind your Lordships of some certain essentials about Mrs Baker. She started work for the first appellant at the age of 15 in 1971. She gave them 30 years of service until the factory closed in 2001, at which point, of course, she was in her mid-40s. Her evidence, of course, was accepted by the judge as being truthful. She tried to recollect the sound levels years later, which was obviously difficult, and something is said about the sound levels in the judge's judgment at paragraphs 134 through to 136. And it's a passage I think your Lordships looked at yesterday where the witnesses, years after the event, were trying to remember whether they needed to shout, which they all thought they did, or whether it in fact was simply a requirement for a raised voice. Now, in fact, the learned judge and my team, Mr Purchase and his team, and those representing the other appellants went to a comparable factory in Belper, and evidence was given about the sound levels at Belper. So we all had actual experience of what it was like to work in, I think the measurements that the engineers took were 82 dBA LEPD. And I'm not going to take the opportunity to give evidence myself to your Lordships of what that felt like. But his honour did have an appreciation of what the sound levels were in fact like. Well, Mrs Baker, at the age of 45, left that employment, and as your Lordships see from the paragraphs that follow 182, she subsequently discovered that she was turning up the television in circumstances that her husband didn't like, and he drew to her attention that it was too noisy. So she was obviously not conscious that she had any hearing loss. She subsequently, as Mr Nolan points out, saw an advertisement which made the connection between any hearing loss she might have had and the possibility that it might have been induced by her work. And so she came to be a claimant in the case. But the final point I wanted to make about Mrs Baker is that although it's right that her noise-induced hearing loss was modest, as the judge found in her mid-40s, it has to be remembered that in 20 years' time, when age-induced hearing loss is added to the noise-induced hearing loss, her hearing deficiency may be a real social handicap to her. Well, that leads me on to say something about the physiology of deafness. I appreciate your Lordships are very familiar with this, and the judge dealt with it in some length right at the beginning of his judgment, paragraphs 3 to 10. But in fact, there's a fuller picture from a man everybody regards as probably the expert, Professor Lutman. It's in Appendix White, Volume 7, at tab 8, and we commend to your lordships paragraphs 4.2 to 7.11. Because I'm not going to take your lordships to it now. But
I'm so sorry, could you give me that?
I'm so sorry, Lord, yes, it's a White Appendix, Volume 7, tab 8, paragraphs 4.2 to 7.11.
Sure.
And the way in which noise-induced hearing loss acts on the human being is that damage is done to the little hairs in the inner ear. They're overexcited by a loud noise, and if they're overexcited for a period of time, they give off toxins which eventually kill them. And there are therefore 3 stages for somebody who ultimately experiences noise-induced hearing loss. The first stage is that damage is suffered, which is neither objectively nor subjectively detectable, but it uses up part of the reservoir of tolerance, as it's referred to, that all human beings have. That's a greater number of hairs than is actually necessary to hear with. The second stage comes when there is damage which is detectable at audiogram by the characteristic notch at the 4 kilohertz level, which is one might describe as objective, the objective symptom stage, although the person in question is unaware that they have any hearing loss or indeed that their ears have been damaged. And then the third stage is damage at a level where the person becomes subjectively aware of it. And of course that's a gradual process. So, Lords, one of the importance of audiometry, which your lordships have seen reference to in the various guidance and regulations and so on, is to pick up injury which is not subjectively perceived, but is objectively detectable, so as to take immediate steps to protect the individual concerned. Lords, from those words about physiology, I wanted to turn to some of the contemporaneous documents in the public domain. Learned friends have referred to several of them. I'm not going to go through them all. Your lordship sees that the learned judge dealt with all the documents, or nearly all the documents, from paragraph 12 onwards, and in particular at paragraphs 21 to 26. And it might be worth me just showing your lordships paragraphs 21 and 22 to see some conclusions that the learned judge drew from the documents. The lordships have core volume 2, tab 6, paragraph 22. His lordship, His Honour Judge English says at the bottom of the page, paragraph 22, he says the result of some of the research material is set out above. 90 dBA is an arbitrary level, and approaching it from 85 dBA, the risk of noise-induced hearing loss in some people is significant and increasing as 90 dBA is approached. The risk going down from 85 dBA was the subject of oral evidence. And then he reviews further documents, the NPL tables and so on, and at 26 he says examples of the sort of threshold shifts due to noise that emerge from the various papers are given above. They differ, but often not by a great deal. If I've simply selected some that have come into evidence in this case, it's not to perform a task of deciding between them, which I couldn't do, but simply to illustrate in general the level of risk of hearing loss caused by exposure under 90 and 85 dBA. And then I pass over the next passage and pick it up 5 lines from the end of the paragraph. 6 lines, he says, nonetheless, the description given to the risk to hearing of exposure below 85 dBA by Professor Lutman in one of the publications set out above as minimal is one that I accept and adopt. Above 85 dBA, the risk accelerates up to 90 dBA. In the high 80s, given long enough exposure, significant hearing loss may be expected in at least a substantial minority of individuals. With those findings, and I pass to the documents that led the learned judge to those conclusions, and may I start with Noise and the Worker in 1963. This is in white volume number 2 at tab 9. Well, this is the first publication of Noise and the Worker. It was the one that Mr. Justice Mustill regarded as absolutely crucial in Thompson and Smith's ship repairing. But I'm not going to invite your lordship to read it because there were 3 editions of this. The second edition is at tab 10. I'm so sorry, your lordship's not got it. It should
My
be
bundle 2.
Yes,
I'm so sorry, my lord. I'm told that white 2 is also in core 3.
Ah.
So if your lordship has core bundle 3
Tab 9.
and goes to tab 9.
Yes, I don't have a white 2 either.
It's
So
perhaps
core,
maybe they've got a
core bundle volume
superfluous one.
3, yes.
Tab 9.
Tab 9, my lord.
Thank you.
So that's the first edition of Noise and the Worker in 1963. And I just show your lordships a couple of passages in it. In the introduction at page 3 of the internal pagination, that's core 901, reference is made to the Wilson Committee of March 1963. And then it goes on, noise is not a new problem in industry, but for a long time it's tended to be accepted, both by management and workers, simply as part of the job. This is still the attitude in many factories, either because the harmful effects of noise are not appreciated, or because it's thought that nothing can be done about them. There's still much to be learnt about the precise effects of noise, and scientific research is being undertaken with this object. Enough is already known about the problem, however, to suggest some measures which can be taken to control it. And then it says it's here to set out some basic facts. Under the heading, how is noise harmful, amongst other things, it says on the next page, on the second line, that most importantly it may damage workers' hearing. And it concludes that paragraph by saying much more serious regular exposure to some kinds of noise over a long period may result in the destruction of certain inner ear structures, those are the little hairs, and loss of hearing which is permanent and incurable. Have you a noise problem? Following points should be considered. 6 of them. 1, do workers find it difficult to hear each other speak while they're at work in a noisy environment? And then there's ringing noises and so on, which deal with, which your lordships don't need to look at. But it concludes by saying, if the answer to several of these questions is yes, there may well be a problem with excessive noise. And then under the heading Conduct of Noise Reduction and Hearing Conservation Programme, the first steps in the programme are to carry out a noise survey and to obtain specialist advice. Lord, there's something said about danger levels of noise on page 7. I'm not going to take your lordship there. At the stage that this document was published, you could measure the sound emitted by a machine but there was no technique for averaging it, still less of working out what the dose was for workers subjected to noise at particular levels. But at page 14, under hearing conservation, it begins by dealing with ear defenders. Where it's not possible by environmental control to reduce noise to sufficiently safe levels, workers should be protected by ear defenders. And under the table on the facing page, it says use of efficient ear protection may have the same value as noise reduction of 20 to 30 decibels. It may be difficult to convince workers that they should wear ear protectors, and a planned programme of education about the dangers of excessive noise to unprotected ears may be needed. The importance of correct fitting should be emphasised. Under monitoring hearing levels, if workers are exposed to levels of noise at or approaching those set out on page 8, which I think we all agreed below was the equivalent of what is now 90 dBA LEPD, it's advisable, where possible, to make arrangements for periodic tests of their hearing. So, Lord, that was the first edition. The second edition is much the same, although that's at tab 10, although it's surrounded by advertising, amongst which is advertising for ear defenders. One can see that on the very second page. Amplivox have got an advert for ear plugs and ear defenders, and there are similar adverts at the end of the document. But the more important version is the final and third edition, which your lordships have at tab 11. The introduction is much the same as before, except if your lordships look halfway through the introductory paragraph.
What's the date of this one?
This is 1972, my lord. 71, forgive me. That's on page 952, the date appears. But at the third internal page of the document, the introduction is found, and after that sentence, which was there in the first and second editions, there is still much to be learnt about the precise effects of noise, and scientific research is being undertaken with this object. They insert this reference: the recent work of Burns and Robinson is particularly relevant. Noise harmful is much the same as before, but under have you a noise problem, the questions, that is dealt with slightly differently. We still have the 6 questions, and the first of which is, do workers find it difficult to hear each other speak while they're at work in a noisy environment? But the concluding paragraph says, if the answer to any of these questions is yes, there may well be a problem with excessive noise. If so, effort should be made to reduce it, or if it can't be sufficiently reduced, for example, where impact is essential to the process, to reduce the exposure of workers to noise, or provide them with ear protection, or both if necessary. And then, as before, conduct of noise reduction hearing conservation programme. First steps in the programme to carry out a noise survey and to obtain specialist advice. Factory inspector rate is mentioned there, but as a source of information about organisations able to give such advice, not advisors themselves. Then over the page, at page 7 of the internal document, danger levels of noise. Exposure to excessive noise causes deafness, may be severe if exposures continue for a long time. Some people are more likely to hearing loss than others. Because our knowledge of the effects of noise exposure, especially exposure to intensive noise of short duration, is still incomplete, not possible to set out a simple table of permissible limits for all types of noise. It is, however, possible to give guidance which will help to protect most people against serious hearing loss. So it's making clear that there will be others who will not be protected. And there your lordships see that in the little table, the exposure is 90 dBA LEPD, that the exposure time is reduced to give a higher maximum sound. Can I draw your Lordship's attention to page 9, which bears the heading Desirable Noise Levels in the top third of the page, under which is written damage risk criteria should be regarded as maximum permissible levels and not as desirable levels. If possible, the noise should be reduced to levels lower than the danger levels set out in Table 1 to avoid risk to the minority of people who are exceptionally susceptible to hearing damage and for reasons of general welfare. So again, it's highlighting the risk to a minority. Well, I don't think we need more until we go to page 13. Just got the familiar passage about hearing protectors under the heading Hearing Conservation, and at page 15, Noise Education, the same passage as was in the first and second editions is set out there. Likewise, monitoring audiometry, which I don't think I read to your Lordships before, but I pick it up in the middle of monitoring audiometry. It says, in such cases, the medical department using an audiometer carries out checks of workers' hearing before employment in a noisy process and subsequently at regular intervals. This can help to detect at an early stage individuals whose hearing has been affected, possibly due to exceptional susceptibility to noise or failure to use hearing protectors or to the use of incorrectly fitted or damaged protectors. And then under the bibliography, which your Lordships have at page 17, publication by Professor Burns. It comes under the references to the British standards. The relevant ones for dose have not by then been produced. There's W. Burns' Noise and the Man, which is His Honour referred to, and at the bottom of the page, Burns and Robinson, Hearing and Noise in Industry, 1970. So, Lords, that's noise and the worker. Can I come then to the Code of Practice, which your Lordships have at tab 13? Your Lordships have looked at this, so I'm not going to repeat that which your Lordships have already seen. Can I draw attention to the forward, however, by the Secretary of State, who of the department which published the code. He says, it's been common knowledge for many years that high levels of noise at work can cause impairment of hearing. Few firms where this is danger, good work has been done suppressing noise. Many others, problem not been recognised or has been underestimated. Those firms' tragedy is all too often the workers are accustomed to the noise and don't notice the gradual deterioration of their hearing until it's too late. Hearing lost in this way can't be recovered. General solution to this problem, which is a complex one, has been hampered more by ignorance than by neglect. Until, and this is, we say, important, until the pioneer work of Professor Burns and Dr. Robinson was published in March 1970, we lacked the necessary scientific knowledge of the precise levels of noise and the duration of exposure to them, which can cause damage. It's largely due to their work that this code of practice has been made possible. Provisions in the code have been recommended by my Industrial Health Advisory Committee. And I think one of my learned friends showed you, Lordships, the rest of that introduction. And on the facing page, as already been noted, Professor Burns and Dr. Robinson of, respectively, the University of London and the National Physical Laboratory are mentioned there. And your Lordships may be interested to see D.E. Hickish of the British Occupational Hygiene Society and the Ford Motor Company. He is a medical officer who figured in the case of Cropper and Fords, which I need to show your Lordship later on. The introduction at the end of the first paragraph concludes regular exposure to sound levels, lower sound levels over a long period of time may result in destruction of certain inner ear structures and a loss of hearing which is permanent and incurable. If there are various hearing conservation measures which may be taken to reduce the exposure of employed persons to noise, and then it mentions noise absorbent materials, control of noise at source, and concludes in that paragraph by saying where such measures are not effective, other measures may be necessary, such as the limitation of exposure to noise and use of ear protection. At paragraph 1, under the scope of the code, your lordships have already seen 112, which says that code sets out recommended limits to noise exposure. Should be noted that on account of the large inherent variations of susceptibility between individuals, these limitations are not in themselves guaranteed to remove all risk of noise-induced hearing loss. So anybody reading this would know that simply adhering to the limits in the code was not going to guarantee to remove all risk to a workforce. 2.2 says reduction of sound levels. As a primary aim, the code seeks the reduction of noise exposure to below the specified limit. As a secondary aim, it seeks the reduction of sound levels generally. So it's not saying to the reading employer, get down to 90 and you don't have to do any more. It's saying this code is asking you to do more, seek the reduction of sound levels generally. Under 3.1.2 says the aim should be the general reduction of noise exposure. And my learned friend shows your lordship the rest of that paragraph. Then
it does say repeatedly that ear protectors and the like are only necessary if you don't achieve the limits in section 4, doesn't it?
That's certainly, my lord, yes, in relation to the use of ear protectors. And then under section 4, limits, 4.1 desirable sound levels. The limits set out in this section should not be regarded as the maximum acceptable levels and not as desirable levels. So they are not the maximum acceptable levels. Where it's reasonably practical to do so, it is desirable for the sound to be reduced to lower levels. And then limiting sound level, people shouldn't be exposed to sound levels exceeding the limits set out in 4.3 to 4.5, and my learned friend showed your lordship 4.3, which poses the 90 dBA LEPD level. Under section 5, surveys and identification of places where sound levels are excessive, all places where it's considered the limit may be exceeded should be surveyed. Surveys are advisable when it's necessary to shout in order to be audible to a person 1 metre distant, and so on. And then under ear protection, on the next page, making my Lord Mance's point at 7.1.1, when the application of means for controlling sound at source or restriction of exposure duration doesn't reduce the noise exposure to below the limit set out in section 4, employed persons should be supplied with effective ear protection on an individual basis. And 7.4 makes the education point. Before protectors are issued, need for their use should be fully explained. Managers, supervisors should encourage use. Education of employed persons should include instruction with their use, care, maintenance, and so on. And over the page in section 10, training of engineers, training of others, 10.2.2, all persons exposed to noise should be acquainted with the hazards involved. And Lords, I don't think there's more your lordships need from the code of practice. My learned friends have referred to framing noise legislation, and this is at, I think it's White Volume 4 at tab 31. course, this is the report by that Industrial Health Advisory Subcommittee. Its date can be seen. I've just lost it for a moment. It's 1975. At the moment, I don't see where the date appears. Anyway, I don't think there's any dispute over its date. I just wanted to pick up with your Lordships paragraph 19 at page 3 of the internal pagination. Paragraph 19 reads, the Code's noise limit of 90 dBA LEQ has widespread international acceptance. Although it doesn't eliminate all risk of hearing damage, we feel it continues to be the most practical standard in recognition of the necessity of concentrating limited resources on workers subject to the most significant risks and of eliminating these risks as a first priority. If the limit were lowered to 85, for example, the factory inspectorate survey indicates that the total number exposed will be more than twice that at 90 and above. Prediction of risks of hearing damage at these levels, based on a lifetime's exposure of 30 or 40 years, indicates that the proportion of an exposed population likely to suffer unacceptable degrees of impairment falls off rapidly below 90. The specification of a daily dose introduces a further margin of safety, since it's unlikely that a large number of workers would receive the full daily limit throughout their entire working lifetime. Similar conclusions in other industrial countries. None in our surveys introduced a generally applicable level lower than 90. Nevertheless, the question of a lower limit should be reconsidered at regular intervals. A level of 90 dBA is by no means ideal, and the aim should be to ensure a progressive reduction, so that anybody reading that would know that there were risks below 90 and that 90 did not guarantee protection. Well, the next document is the protection of hearing at work, which my learned friend Mr. Beloff referred to in 1982, and that's in the fourth core bundle at tab 19. Thank you. Your Lordships see that this was 1982, and we draw attention to the introductory passage at core 1322, where there's a table above which is written that information given in figure 1 may be represented in tabular form as table 1, and then level of exposure in dBA LEPD for a lifetime's exposure and for 10 years exposure. So if one took a lifetime exposure, the percentage of persons likely to suffer a 50 decibel hearing loss would be 32% if it was 100, 11% if it was 90, and only 3% if it was 80. So that the 85 level would be somewhere between 11 and 3. And that actually can be seen from figure 1 over the page, where your Lordships see graphs. They're marked at the 80 and 90 and 100 dBA LEPD level, but one can easily see an imaginary line, a perpendicular line going between 80 and 90 at the 85 point mark, which shows that it would intersect at a level above 80 and below 90, as one would expect. That's the shape of the graph indicating the percentage of those likely to be affected after 10 or a lifetime's level of exposure. And those conclusions on the page where the introduction is found are set out in text in paragraph 2, and in paragraph 3 it reads, in other words, a reduction of level from 100 to 90 achieves a saving of 21 persons in every 100, and a reduction from 90 to 80 achieves a further saving of 8 persons in every 100. Similar calculations can be made at different levels, exposures, durations, and degrees of hearing loss. It's clear from these figures that the degree of reduction of risk achieved by reducing the level from 100 to 90 is much greater than that achieved by reducing from 90 to 80, and that the maximum benefit in terms of protection of hearing will be gained by directing the major effort at noise control towards those exposed above 90. Nevertheless, it's clear that there is still a risk, albeit less, at levels below 90, and this merits appropriate action where it's reasonably practicable. So, unambiguous guidance there. My Lord, finally, I think just to paragraph 19 on page 5 of the internal pagination, reduction of exposure in order to avoid any risk of imposing an unreasonable burden on industry. Proposed obligations on noise reduction will be bounded by reasonable practicability, thus ensuring the regulations have built into them sufficient flexibility to ensure that cost is not unreasonable in relation to the benefits in any industrial sector, to ensure the greater effort is directed towards areas of greatest need. It's proposed that exposures above 90 carry a sufficient presumption of hazard to justify extension to the whole of industry of the duty placed on employers in the woodworking machines regulations. And
where was that?
I'm so sorry, Lord. Paragraph 19 on page 5.
Oh, yes, I have it. Thank you.
And may I just pick up finally at paragraph 21 on the same page. Commission is aware of the strongly felt and differing views held about the adoption of 90 dBA LEQ as the main action level for requirements concerning noise reduction, and indeed other requirements concerned with worker protection. However, when coupled with a general requirement proposed, this value should help promote substantial improvements in industry, especially as in practice employers and others will need to set themselves a design target 2 or 3 decibels lower than specified in the regulations. Proposal therefore seems a sensible first step in legislation, though the Commission will keep the question under review and will consider whether to propose some lower value if this seems correct in the light of future developments. Lord, then can I take your Lordship to HSE Prevention of Damage to Hearing from Noise at Work, cited by Mr. Nolan yesterday. That's in this volume at tab 23. And the date of this is 1987, as appears on the front page. Can I pick it up in paragraphs he didn't read to your Lordships? Paragraph 6 on page 2 of the internal pagination. Proportion of people who will be affected and the severity of their loss depends on several factors, including the duration of exposure, age, contributory loss from other causes. Table 1 shows the proportion of a typical industrial population who'd suffer hearing loss if exposed without protection to noise at work until the age of 55, based on a recent report by Professor Robinson, the Institute, who was commissioned by the Health and Safety Executive to review the current British and international standards on risk and re-examine the available evidence. It shows that without noise exposure, about 12% of persons would, by 55, have a hearing loss defined as significant in the current British standard, and that exposure for 37 years at 90 dBA would cause this to rise to 30%. So the difference is that the noise-induced hearing loss would be 30 minus 12, which is 18%. And one sees that over the page in table 1, the percentage of 55-year-old workers likely to suffer 30 and 50 decibel hearing losses, and it's actually measured for 85 at 85 dBA LEPD. Some 16% would suffer a hearing loss of 30 decibels. At 90, that's increased to 30%. And my learned friend Mr. Nolan drew your lordship's attention to paragraph 9.
What does the none indicate there? That means no noise exposure, presumably. Is it?
Yes, my lord.
And so 12 is the aging, is it?
That's the age.
Your
indeed.
aging. So the increase as 85 is simply 4, which is a third, and then at 90 it goes up to 30.
Yeah, so as in all these tables, and I'll show your lordship the British standard and the international standard in a moment, one subtracts what the hearing loss would be without noise exposure.
Yes.
So at 85, 16% of workers suffer 30 decibel hearing loss, but 12 of them would have suffered that through age alone. So it's an additional 4%.
Yes.
And at 90, it's 30 minus 12, which is 18%. And then Mr. Nolan drew attention to paragraph 9, at the end of which it's written, over all industries, it's estimated about 1.7 million persons may be exposed above the 85 action level, and over 630,000 above the 90 dBA action level. And Mr. Nolan says, well, that shows the scale of the problem. We don't dissent with that. It doesn't mean that one ignores that 1.7 million persons. And in the table which follows below, one can see the estimated number of persons exposed to noise in manufacturing. The number of persons in the range 85 to 90 is 710,000, and 90 to 95 is 275,000, and it gets smaller with the greater noise. So, my Lords, all these documents indicate that there is a risk below 90. That risk became quantifiable after the work of Burns and Robinson, and I'd just like to show your Lordship the tables that enable the reader to make the calculation. Well, I start with the International Standards Organisation, 1975. It's ISO 1999. Shouldn't be confused with the date. The date is 1975. It's tab 14 in your Lordship's bundle, core volume 3. And it has been suggested from time to time in the years of this litigation that this is a very difficult exercise to undertake, but we say not so. If your Lordships go to page 6, Annex B, there's a table for the estimation of risk involved, and it says A, relation between equivalent continuous sound level during work 0 to 45 years and risk of hearing impairment for conversational speech. So there are then the risk at 80, 85, 90, and so it goes up.
I'm sorry, I've lost you.
I'm so sorry, my Lord. It's tab 14 in core volume 3.
Tab 14,
14, yes, my Lord.
core 3. I'm looking at the wrong report, but I beg your pardon, I'm so sorry.
Oh, it's my fault, Lord.
Just before tab 15. Won't be wrong about that.
It's Annex B at page 6 of the internal pagination, which is the last page.
Yes, I have it.
And Lord, the technique for this is simply to deduct the risk percentage in the upper line from the total with impaired hearing in the lower line. So at 85 dBA continuous sound level, after 40 years exposure, by way of example, one subtracts 10 from 43 with the result that one has 33% with impaired hearing. Now, if one takes...
What does the risk mean then?
I'm so sorry, Mr. Huckles told me I got it wrong. So can I just take a moment, Lord? Yeah. I'm so sorry, Lord. Yes, we should... He's right. We should be ignoring the line risk percentage, and what one does is to assume that less than 80 is the normal exposure of a population, so that the 33% of people at less than 80 who have suffered impairment for conversational speech have acquired it in a way other than exposure to noise at work. So if one then takes the 40-year exposure for somebody at 85, which gives 43, you take 33 in the less than 80 exposure from 43 in the 85 exposure, and the result is 10. And that is the risk which has already been calculated for. So the answer to my Lord's question is the risk in percent, with nothing added to it, is that a subtraction having been done. One can illustrate that as by deducting the two as one goes along.
And is that intended? That's a risk in percentage of people, 10%.
Yes, in a population exposed to noise at that level for that many years.
Well, each of those is an increase in the 33 level, isn't that right?
Yes.
Yeah. So it's 10 at 85, and it's 21 at 90 and so on.
That's right, Lord, exactly. And 29 at 95. So in spite of the fact that I've forgotten how to do it, Lord, it is nevertheless quite straightforward.
Does it tell you how much hearing loss, say, would suffer?
I think it does, my Lord.
It's 25 dB, average across half.
Where does it say that? It's a 25 decibel sound loss averaged across certain I've got it, my Lord. It's at page 1 under scope and field of application, paragraph 1. This international standard gives a practical relation between occupational noise exposure expressed in terms of a weighted sound level, blah, 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 and the percentage of workers that may be expected to exhibit increased threshold of hearing amounting to 25 decibels or more, averaged over the three frequencies, 500, 1000 and 2000 hertz, solely as a result of noise exposure. Yes, Mr. Huckle reminds me that that's already at the level which would justify or warrant or require hearing aids. Lord, the next document is at tab 15. This is the British Standard of 1976. There was an earlier international standard in 1971, but the results were, or the techniques were not so clear to use. In the British Standard of 1976, BS 5330, in the forward, on the back of the front page, at the bottom of the left-hand column, it reads, this standard is based on data which give in statistical terms the relation between different noise exposures and the permanent noise-induced threshold shift in people of various ages. These data apply to persons free from auditory impairment other than that due to noise, with allowance for the effects of age, having substantially similar hearing levels in both ears. The risk of sustaining handicap is estimated in terms of the handicap percentage. This is the percentage of noise-exposed persons attaining or exceeding a particular average hearing threshold level at which a hearing handicap is deemed to exist. Noise exposure is quantified in terms of the noise emission. Handicap percentages tabulated for different noise emission levels and ages. And one of my learned friends drew your Lordship's attention to the reference to the code there. Lord,
so is this a different exercise from the one in the previous tab?
It is, my Lord. It is a different one, but it's of no greater difficulty. What one does is to go to Table 3 and Table 4, and in Table 3 you have to derive a noise emission level, an NIL, and that's relatively easy. You take in the left-hand column your noise level, let us say for the sake of argument 89 dBA LEPD. You go across the chart to see how many years that person has been exposed. If we take this person as being exposed for 40 years, that would read as a noise emission level of 105. You then go to Table 4 and you put your noise emission level in the left-hand column. 105 is obviously somewhere between 104 and 106 on the left-hand column. You read across from that to see what age they are at present time. 40 years, let's assume they were 60, and you get a 13, a loss of 13. You don't stop there, however, because you have to subtract from it what the unexposed population would have suffered. As in the ISO table, you use the 80 dBA level. So you go back to Table 3, read across from 80 for 40 years, that's 96. So you look to see what an NIL of 96 would be for a 60-year-old. You see it's 3. You therefore take 3 from 13, and that gives you an exposed population of 10%. Straightforward once you've been shown how to do it.
Is that the same 10% as we looked at before?
More or less, my Lord. There are very slight differences. One of them is the hearing level loss. Here it's 30 dBAs and the frequencies are slightly different. But His Honour, Judge English, found that there was no significant discrepancy between the figures.
It can't be the same 10% because you started off with a different sound level. You started off with 89 instead of 85.
Absolutely, my Lord. But if you do the comparison, it's more or less the same. I think His Honour said that. I was just plucking examples from the air, I have to say, rather than looking to do a comparison.
I noticed that at paragraph 101 of Lady Justice Smith's judgment, she says that she fixes on this document as the first document by reference to which the calculation could be done by an ordinary engineer. So she, for whatever reason, and she doesn't say why, but for whatever reason, she does not agree with you in relation to the earlier document that you showed us, but she does agree with you in relation to this document.
I think nothing turns on it because there's no magical difference between
the dates are very close
of the two documents, my lords.
You know, this is the critical document. As far as
This is probably the critical document, but the other is to the same effect. That's all I'm saying. And my learned friend Mr. Kent this morning with this document said, well, 30 decibel hearing loss, in order to ascertain what that means, you have to go to the Coles-Worgan scale, but we don't understand why that should possibly be, because this document itself tells you what the level of 30 decibel hearing loss across those frequencies mean. If your lordships go back to page 1 of this document, that's core 1110, at paragraph 3.5, it sets it out. Permanent impairment of hearing for conversational speech due only to the effects of noise and age is the heading. The hearing of a person is deemed to be impaired sufficiently to cause a handicap if the arithmetic average of the hearing threshold levels for the two ears combined at 1, 2 and 3 kilohertz is equal to or greater than 30 decibels, referred to in the audiometric 0 of British Standard 249.7. And that is the reference at table 4. So it's an impairment of hearing for conversational speech. So, Lords, the importance of these aids to calculation is not, as everybody accepts, that any ordinary employer could perform the calculations, but engineers certainly could. And they demonstrate that an employer subjecting a workforce to 85 LEPD for a period of years is going to not expose them to a risk, but to expose some of them to the certainty of noise-induced hearing loss. And when in Mr. Beloff's written case at paragraph 103, it is said that the Court of Appeal imposed liability for, and I quote, dangers entirely unknown at the time, that is simply not the case. These dangers were known, certainly from 1975. And His Honour Judge Inglis, in findings which are not under appeal, makes the danger clear. Can I show you, Lordships, paragraph 87 of his judgment? A crucial paragraph in our respectful submission. He says, there is no doubt that research into the question of what risks to the hearing of employees' exposure below 90 posed would have yielded the answer that 90 dBA was not a natural cut-off point, and that there were risks to susceptible individuals below that level. Indeed, the 1972 guidelines, he means the Code of Practice, themselves made that clear. From the early 1970s, certainly by 1976, with the publication of British Standard 5330 and ISO 1999, in the previous year, the information was available, if researched, to give an indication of the level of the risk. It was a level of risk that came by the end of the 1980s to be seen as unacceptable, if not accompanied by at least voluntary protection, though the 90 dBA limit had remained, and in 1981 the proposed regulatory standard. And a couple of lines further down, after him expressing the view that he wasn't persuaded that employers who conformed were in breach of their duty of care, he says this: in rejecting the primary case for the claimants, I acknowledge that I do not see the issue as only one of foreseeability. It would, in my judgment, be futile to hide behind the 1972 guidelines for that purpose, or behind the third edition of Noise and the Worker, when the documents themselves proclaim that the level proposed will not be safe for all workers. But good practice, as well as is informed by official guidance, has, in my view, to be taken into account as well. Well, that's another issue that I have to deal with later. But the important finding is that the 1972 Code, Noise and the Worker, British Standard and the International Standard revealed a risk to workers which could not be hidden. And then I pick up that paragraph a couple of lines further on. There's a line that begins with the word employees, and he then says, to put it in the context of Mr. Justice Swanwick's judgment, complying with 90 dBA LEPD as the highest acceptable level was, I think, meeting the standards of reasonable, prudent employers during the 1970s and 80s, certainly until the time of the 1986 directive became generally known in 1987. I accept this means that employers were not bound in the discharge of their duty to ask the question, who are at risk in my factory and how big is the risk? It's a question none of them in this case asked. And we would say, from what the judge had said earlier in that paragraph, it's quite clear that had that question been asked, the answer would have been there are people at risk in your factory and they face a small risk, and I can tell you what those are if you tell me what the sound levels are and how long they're expected to work there. Well, that was 87, which I have to return to for other purposes later on this afternoon.
So you say that, is this right, that on the judge's findings of fact, at least, it was reasonably foreseeable, indeed certain, that they would be exposing, if nothing was done, they'd be exposing some people in the 85 to 90 hearing range as being at risk? Absolutely,
my Lord. And really, I suppose in your Lordship's court, I shouldn't have needed to trouble you with the original documents, but it's interesting to see those original documents to give context for the judge's factual findings in paragraph 87. But those factual findings, as we understand it, were not appealed in the Court of Appeal, and of course are not appealed here. Lord, there's one other sentence where the judge makes the same point in paragraph 99. Here he's dealing with the question of the knowledge or the standards to be applied. At the foot of that page, in the last full sentence to appear, he says, moreover, reference has only to be made to the 1972 Code of Practice to see that the 90 dBA LEPD standard is not to be regarded as safe for absolutely everybody. And he says over the page, having set out again that in his view the section 29 has to be construed in accordance with the guidance of the day. If your Lordships look at the last half of paragraph 99 as it appears on the next page, there's a line which begins with the words exceeding 90 dBA LEPD. He says, if I'm wrong about that, that's whether the guidance of the day holds sway, if I'm wrong about that and the standard of what is safe has to be judged entirely objectively without reference to the standard that should reasonably have been adopted by employers, then it would follow that liability under section 29 would fall on an employer where an employee was exposed to noise levels at and above 85 dBA LEPD and has suffered damage in consequence. Obviously he's addressing a different question there, but in our submission is a repetition of what he had gleaned from the documents, the earlier documents, about the degree of risk.
Another way of putting the sentence, the final full sentence on page 533 is that reference has only to be made to the 1972 Code of Practice to see that the 90 dBA LEPD standard is to be regarded as unsafe for some.
Indeed, my lord, indeed.
So on this footing, the critical point is the one you mentioned at the top of page, the one in paragraph 87,
Yes.
about good practice and industry standards and the like, notwithstanding these conclusions.
Yeah, I'm so sorry, Lord, I'm missing the...
Well, the critical point is that, okay, accepting that the judge's findings about reasonable foreseeability and the like, that's only one factor.
Yes.
And that employers have to be judged having regard to the general standards in the industry.
Indeed.
And we know what those are. They've been promulgated in the various documents we've looked at.
Indeed, that's a separate issue that I have to come to.
But it becomes the critical issue.
Yes, but, Lord, the first issue is an underlying submission from the learned friends that nobody really knew that there was a danger in the early 1970s, and that clearly is not the case. This is a risk that's known. And I make a point that the learned friends have also made. Nothing changed about this knowledge. The same knowledge that informed the British standard in 75 and the international standard in 1971 and 1974 is the knowledge that persists today. There's nothing new has emerged from it. It's right that the guidance has changed and what may be regarded as acceptable may have changed, but that which is safe and unsafe so far as exposure to noise at work is concerned has remained the same for the last 40 years, or just under.
So if you were to do the exercise for Mrs. Baker,
Yes.
on the basis of the 5330 standard, and can you do that exercise, applying the tables?
Yes. I would just say this, my lord, that before one does that, it raises a question, which again I have to answer later, is when the exercise has to be done.
Yeah.
Because Mrs. Baker has the advantage for the purposes of calculation that all her noise exposure was with the one employer. But other of the ladies who brought claims, of course, had worked elsewhere first, and they were older. Mrs. Baker starts at 15, but some workers are obviously going to start in their 30s, and they may already have 20 years of exposure to such levels. So it's not as if, I think I made this assumption at the beginning of the litigation, that one looked at it as if the whole workforce had started at the moment when one carried out the predictive test. But of course that's not so. The workforce will be, some will be new, some will have been there for many years, some will have had exposure elsewhere, some will not. I'm digressing from your lordship's test. Of course, I'll now be completely unable to carry it out, but I'll
Well, don't do it now if you can't do it. And it may be for the reasons you've just given that it's perhaps it's not a very useful exercise.
Well, I think it can be. We could certainly do it retrospectively.
Yes.
And of course, these tables can't apply to individuals. We know that. They only work for a population.
Yes.
But let's assume a population of Mrs. Bakers. If one looks at the British standard, one would take, and we'll look at it at her at the age of 45. So under table 3...
Sorry, which page are you on now?
Lord, it's page 4 of tab 15. And Lord, her exposure, I think, was at about 86. Let's assume 86 for the sake of argument. So we go down the left-hand column to pick up 86. We read across to 30 years exposure. We've got an NIL there of 101. So we go to table 4 with 101, which is obviously between 100 and 102. We know that her age is 45. So we've there got a percentage of 2. Sorry, yes, it's going to be 3, isn't it?
Three.
Obviously, between 2 and 4. And we've got to deduct from that a DBA at 80 going across to the 30-year mark, which gives a NIL of 95. 95 then read across on table 4 at the age of 45 is 1. So 3 minus 1 would give 2%. 2 Mrs. Bakers in 100 Mrs. Bakers would have suffered.
Are these robust? I noticed that the judge says that there's a degree of uncertainty about whether any figures below 85 are in fact accurate.
Yeah, there was a lot of discussion about that, my Lord, about the degree of reliance below 85, but it was accepted that at 85 and above they were robust, my Lord.
What he says is above 85 the risk accelerates up to 90. In the high 80s there can be, given long enough exposure, significant hearing loss expected in at least a substantial minority. Below 85 it's minimal.
Yes.
One gets the impression that 86 is just above minimal.
Well, indeed, and we've just, I think, illustrated that with our population of Mrs. Bakers, my Lord. It's a very small number. As it turns out, but of course, say to your lordships, the population is not all of Mrs. Bakers, and one doesn't do it retrospectively, one does it prospectively, and prospectively, if one had done this in 1971, which of course this information wasn't available for, one might have anticipated that somebody at age 15 starting in the profession, perhaps thinking that there might be breaks for maternity and so on, might easily accomplish 40 years before, or 50 years even, before retirement. And then, of course, the percentage increases dramatically.
Your irreducible minimum is that when this British standard became available, a prudent employer properly addressing the code of practice would come to the conclusion that if he was exposing his workforce to 85 dBA LEPD or above, that some of those would be at risk of hearing loss.
Exactly same, Lord.
That's
Yes.
the basic proposition.
It is.
And how much further down would you go before you got to nil, so to speak?
Got to nil, my Lord. Well, in fact, if your lordships look at these tables, even at 80, there is still a risk. But we accepted before His Honour Judge English that a convenient cut-off point was 85, below which it couldn't be said on this information that there was really a material risk. My Lord Mance picked up the word minimal, and we would accept that. Now, in fact, since then, the European directive have prescribed that action should be taken at the level of 80 in order to cut out all risk, absolutely. But the gradients show that there is still some risk between 80 and 85, but it's convenient to regard that as not a material.
Well, it may be convenient, but it does mean that you accept that there is a point at which, although there is a risk, a known risk, indeed a certainty, the employer isn't obliged to do anything.
Yes, well, partly it's because, of course, human longevity is limited, and particularly the working life. I mean, if somebody was exposed to 80 and managed to work for 60 years, or there were a workforce worked for 60 years, it may well be that there was a significant risk, but that would be so unusual that it's appropriate to accept that no action should be taken below 85. As my learned friends have pointed out, our argument before His Honour Judge Inglis was that there should be liability at 80 and above. We lost at 85, and we're content to accept that. We can see that there's an argument to say, well, it's not material. Lords, before I leave this subject, there's just one other document which I would ask your Lordships to look at. It's in Core Volume 4 at tab 20, and we may need to make reference to it in another connection later. This is the European Commission's proposal in 1982.
Core volume.
Core Volume 4, my Lord, at tab 20. Lord,
Can I just go back on the point you've just been discussing? You are arguing that the crunch date is 75, 76. But, of course, you're not challenging, at least you haven't cross-appealed formally, against the judge's finding that there was no common law breach of duty until, in the case of the big firms, at least early 83.
That's so, my Lord, although we've made it absolutely plain that we're not relinquishing our position on that, on our logic and the argument that we've advanced all the way through, liability should have been incurred earlier than that.
I thought so. You say the logic of your argument is actually that there should have been a finding of common law breach of duty from 76 onwards.
In fact, we put it earlier than that because we say from 1963, Noyes and the worker employers knew that there was a risk and they should have taken action over it. But I'm not advancing that before your Lordship. That's simply our position. We are content. Mrs. Baker doesn't want to argue about 1983, since that's the date that was accepted.
But for the future in other cases, what then?
Lord, that'll be for others to argue. That may well be the case. The principles are clear, and some of the cases find liability not at 85, but at much higher noise levels long before 1963. Mr. Justice Mustill's judgment was regarded as crucial when it was promulgated, but since then, in fact, judges have gone back and said, well, 1963 is not the natural cut-off. In the shipyards in Belfast, it's been held that liability was incurred from 1953 onwards because the shipyard employers knew that there were risks to their exposed shipwrights and riveters and so on from that date.
I mean, it's quite important as to how we put it. If we accept your case, you're inviting us to accept it on the basis of material which would lead to the logical consequence that in other cases there was liability going back, certainly you would say to 75, 76, and I think you just said going back to 1963, actually.
Yes. But my Lord, we do accept the proposition that the date of knowledge has to be determined in every case.
Sorry, the date of knowledge being?
The date of actual or constructive knowledge of a risk on which the employer should have acted. So I'm not inviting your Lordships to establish once and for all time that there was a date of knowledge prior to 1963 or at 1963 or prior to 1976.
Well, that has to depend on the evidence in the individual case, doesn't it?
Exactly so, my Lord. Exactly so.
I mean, I asked my question because I understood that these are test cases.
Yes.
And I wasn't quite sure in respect of what they were test cases.
They were...
Because presumably, we take the point we're just on, at some future debate, in some future case, there'll be endless debate about what the Court of Appeal said on this very question, looking at these very documents, or some very, very similar. Well, they'll be the same documents.
Yes, well, these very documents have figured in other cases.
Previously you were saying that the Court of Appeal's conclusion on the common law arguments, at least, is wrong.
Yes.
But of course now there is a decision to that effect, and I was just concerned as to what's going to be happening in some future case, not for Mrs. Baker, but somebody else. And it certainly ought to be clear at the end of any judgment we give, whichever way we give, what points are live and what aren't.
Yes, yes.
Because it may be a bit artificial to say, oh well, each case depends upon its facts and the precise knowledge varies from case to case. No doubt it does, but the truth is that these documents will be the same documents in every such case.
Apart from private knowledge.
Yeah, I follow that, but in the general run of things.
Yes.
And indeed, the whole point of this sort of litigation is to try and, presumably, cut down future litigation.
Lord, may we
entirely.
reflect a little on the proposition your lordships have put to us overnight and come back to your lordship?
Well, I'm not inviting you to take any further points, and you've taken such points that you...
I noted down, I may have to qualify it in the light of what you've just been saying, I noted down that you answered Lord Kerr a moment ago, your irreducible minimum is that a prudent employer would conclude that some employees were at risk of hearing loss from this time on. But I think what you've now said is that it's not or every prudent employer. It depends on something else. You can't generalise. It depends on actual knowledge, and that leads you, does it, into distinctions of the sort that the judge drew, and indeed the Court of Appeal, I think, maintained as regards the interveners between big and small companies and companies which happen to have on their file some document and companies which don't.
Yes. Well, my lord, can I address that question next? That's logically where I was intending to go. So, but before I do, can I just show your lordships this commission document? Probably the wrong place to do it, but it's only a short point. So this is tab 20 of Core Volume 4, submitted by the Commission to the Council on the 18th of October 1982. You see in the left-hand column that it's drawn up. It comes from the Commission, drawn up from by its advisory committee.
But how much weight can we give to a document like this? I mean, the Commission, if I could put it like this, regularly pushes the boat as far as it can, and the Committee of Council of Ministers cuts it back. One has to examine the underlying material to get anything more than a Commission policy.
Well, as I say, my lord, it's a very short point. The short point is this: that this proposal indicates a risk at 85. That's all. Anybody reading this would think, well, there is a risk at 85, no more than that.
I'm not sure it proves a risk at 85. I mean, the Commission is very heavily lobbied. It attempts to come to independent views, no doubt, but they aren't. They are sometimes controversial, and proposals get withdrawn. I find you're putting quite a lot of weight on what is actually no more than a draft bill put before the Council of Ministers, and represents no more than the Commission aim or hope as a starting point before it's been considered by Parliament, before it's been considered by the Council of Ministers.
Lord, I accept all that. And really, it doesn't add to what I've already shown your lordship. It just shows that somebody in the Commission clearly thought there was a risk at 85. Otherwise, they wouldn't have made that proposal. It goes no further than that, in effect. So, and we know that.
Although they were subsequently willing to abandon Article 4.
Yeah. Part of that was no doubt due to the lobbying of Mr. Purchas's clients. The law is very, very hard.
I'm sure you're right, but it's very difficult to draw, it seems to me, objective conclusions about the actual risk without seeing the underlying material.
I certainly shouldn't think the intervener studied it much.
Lord, can I come on to the question of knowledge then, and this issue of special knowledge or greater than average knowledge. Lord, the authorities on keeping abreast of knowledge are clear. Mr. Justice Swanwick, amplified by Mr. Justice Mustill in the Thompson case. And if employers acquire knowledge of risk, then plainly they must act upon it. We say that where the knowledge comes from public documents, publicly available, then employers should be taken to know it. So whether they have actual knowledge of it or merely constructive knowledge of it, employers are bound by the knowledge in the public domain. And in relation to that, we make respectfully no exemption for small employers and seek to impose no higher duty for big ones. The special category, in our respectful submission, is reserved for employers who have knowledge from private sources. And if they have knowledge from a private source that's not publicly available, knowledge that their workforce faces a risk, then they must act upon it. And that, in our respectful submission, is the basis on which Lord Justice McDermott in the Baxter case held that the date of knowledge in the Belfast shipyard should be 10 years earlier than Mr. Justice Mustill had found in the Thompson case. Can I just show your lordships the Baxter case? It's volume 8 of the authorities at tab 23. This is a case in which, conveniently, if it was of assistance to your lordships, at paragraphs 14, 15 and 16, Lord Justice McDermott sets out the guidance in Stokes and Thompson, and at paragraph 33 he adds to it with some words from Lord Justice Geoffrey Lane, as he then was in McCafferty and the Metropolitan Police, all to the same effect about keeping up with knowledge. But the passages that we draw particular attention to are paragraphs 19, where his lordship says, for the plaintiff in this case to succeed at common law, he has to satisfy me employers in breach of their duty in some respect of all of the years 1953 to 1963. Thompson's case, Mr. Justice Mustill was not prepared so to hold. He expressed himself thus on this critical issue. Various years were selected as rough markers for the purpose of argument. I reject without hesitation the notion that the date lay somewhere in the years immediately preceding and following the Second World War. It wasn't until 1951 that even a really enlightened employer would have started to ask himself whether something could be done. Even then, consider it pitches the standard of care too high to say an employer would have been negligent from that date in failing to find, decide upon and put into effect a system of using protectors then available. The other extreme, I consider that the choice of date as late as 1973 can't be sustained. The problem and the existence of different ways in which it might have been combated have been well known for years. There have been devices which were both reasonably effective, reasonably easy to wear, and if employers didn't know precisely what they were, they would have had no difficulty in finding out. Then His Lordship reviewed the historical material, and at paragraph 34 says what advice was available in the decade 1953 to 63. I think it can be summarised under 3 headings, and then he sets out the medical evidence. Medical officer was bound to have said, at least I think so, I've heard of Boilermaker's deafness, we should consult specialists and so on. In response to what can be done, answer would have been ear protection. What does that mean? Earplugs or ear muffs. And then scientific, defendants should have sought advice as to what was known about noise, how it could be controlled, and so on. Knowledge in that decade was much less than what it is today, but there was, I'm satisfied, enough known to have warned the employers the nature and extent of their problem and to have brought home to reasonable employers that some sort of ear protection was required. If these employers had shown an interest in ear protection, I'm sure it would have stimulated interest in other shipyards, and it would become apparent to manufacturers that growing interested market was arising. Legal, company solicitors aware of cases such as Christmas and Paris, which he dealt with at paragraph 22, if asked, would certainly have advised that the defendants were under a duty to apply their minds to the question of safety and health among the workforce. There was no answer to say no other shipyard provided ear protection, and in any event, the men would not be bothered with such newfangled appliances. No doubt the solicitors would have advised that there was no reported case in the British Isles of liability based on a failure to provide ear protection, but they would have emphasised that that didn't mean that the law had ruled that such protection was not necessary. And then at paragraph 38, he refers to Kavanagh's case and Morris and West Hartlepool, Lord McDermott, saying whatever the approach in the last analysis, test to be applied is still the standard of a reasonable man. At 39, applying that test, remembering I'm seeking to assess whether or not Hull and Wolff acted reasonably a long time ago, namely during the decade 1953 to 63, my clear conclusion is that they failed to take reasonable care for the safety of the workforce. In failing to consider or take any steps to deal with or reduce the harmful effects of noise which they knew was injuring the members of their workforce, they were negligent. Reaching this conclusion, appreciate that I differ from Mr. Justice Mustill, aware of Mr. Morrow's argument that it's undesirable that liability shouldn't be approached in a similar fashion in respect of each shipyard in the UK. Standard of care is the same in each shipyard. Haven't sought to impose or apply some higher standard of care upon these defendants. Difference is that, in my judgment, Hull and Wolff did not take reasonable care in all the circumstances. So, my Lords, he appears to us, respectfully, to be saying, well, these shipyard employers knew from their own experience that their men were getting deaf from the noise, and that is what triggered it, rather than any documents in the public domain, such as that which had triggered liability in the Thompson case. Lords, we accept that there are situations where a big employer with the resources to gain private knowledge may be liable if it fails to acquire it. And one example of that is in the VWF, miners' VWF cases, Armstrong and British Coal, which is in volume 1 of the authorities at tab 4. This is the first of 2 Court of Appeal judgments in the Armstrong litigation, and these were test cases to see whether miners working underground with portable vibrating tools such as rock drills and air picks and so on could bring a claim against British Coal for exposure. Now, British Coal had taken the position that they had no knowledge at all that miners suffered from VWF, but nevertheless they carried out a small inquiry in 1967, and that's referred to at page 28 in Lord Justice Judge's judgment, as he then was. And at the foot of page 28, they refer to the Milne survey. It's some 8 lines up, reading, at all events, as a result of Dr. Milne's inquiry, however inadequate, there was evidence that the defendants had a problem. Sorry, that's a quotation from the learned judge at first instance. The learned judge reminded himself of Dr. Rogan, the chief medical officer, intimation to Mr. Milligan, an official in the Coal Board, in 1967, that if the limited inquiry were to indicate that vibrating tools produced abnormal signs or symptoms in coal miners, the launching of a wider investigation would be discussed with Dr. Stewart, another medical officer. As the judge accurately summarised, put shortly, it did and he didn't. From the time of the receipt of Dr. Milne's report, the defendants were on notice there was a possible problem with significant incidents of VWF. Before the report could be written off as a rogue result, defendants now needed to investigate to show that they were a rogue result. Defendants were now on notice that a wider inquiry was called for. My judgment, finding that an epidemiological survey of underground workers should have been carried out after the Oldershaw and Milne reports, it was unassailable. The finding didn't of itself provide the answers to the questions posed to the judge, and then I needn't read further. So that was a case where a huge employer had particular private knowledge which should have prompted it to carry out an epidemiological survey which the learned judge found would have revealed widespread VWF amongst the mine workers, and that formed the basis of the date of knowledge in that case. So that's an example of private knowledge, not gleaned from public documents. And that, in our respectful submission, is the special knowledge case, the greater than average knowledge. Now, in the instant cases, Lords, that special knowledge is immaterial. Nobody says that any of these appellants or the intervener had special private knowledge. The knowledge on which the judge founded was all material in the public domain. Some of them, of course, say, the intervener, for example, says, well, we didn't have actual knowledge of the material in the public domain, but we say that nevertheless, they must be taken to have constructive knowledge, and there is no exemption for small employers in relation to public domain knowledge. Of course, there may be an argument in a particular case about the status of a public document as to whether it was widely accessible or not, and so on. That doesn't really arise in these cases. And looking at the looking at the noise-induced hearing loss cases in which liability has founded below 85 dBA LEPD, at between 85 and 90, looking at those authorities, apart from Baxter, which was founded on private knowledge, all the rest appear to be founded on public domain knowledge. If I may, Lords, I'm going to take your Lordships to the three cases that illustrate that, because they are relevant in another context as well. The first
it isn't surely a question of constructive knowledge, is it? I mean, you simply have to do what a reasonable employer in your position should do.
Yes.
And then the next question is, what would you find out if you did that? But are you really saying there's no distinction at all between the employer of one man and, say, a huge corporation as to what researches they should carry out? And the idea that the intervener had constructive knowledge of anything is very bizarre.
Well, Lord,
You may say, well, such a person ought to take this, that, or the other step qua employer. But I wonder whether it's really right to say that there's no distinction, or even no conceivably potential distinction as a matter of law between a huge corporation on the one hand and a one-man band on the other.
Well, the difficulty is, my lord, is to know where the line is to be drawn in relation to constructive knowledge of public documents. That's really the difficulty.
But I'm sure, why does one have constructive knowledge of a public document?
Because you might be like the interveners that say we never saw these things. So we didn't.
The question would be what somebody in the position of the intervener ought reasonably to have done, surely.
Absolutely, my lord. Well,
that might be different from what somebody in the position of court holds, or the state
Yes.
should have done, or the National Coal Board.
Yes. Well,
Surely.
Lord, this is not a fundamental part of the
I follow
case.
that.
If your lordships think that there is such a distinction, we wouldn't argue strongly against it. It seems
I'm
to
not
us-
saying there is. I mean, I don't know whether there is.
Well, if one applies the standard of the reasonable employer, I can see the force of the argument that reasonable employers are going to differ according to their scale. But it is difficult to see how, if a small employer is bound by the Factories Act, and Mr. Kent made that point, it applies to a one-man band or two people working under the arch of a railway line, just as it does to a huge factory. It's hard to see why they shouldn't equally be regarded as requiring the same knowledge of risks from material in the public domain.
Other aspects are different, though, aren't they? I mean, reasonable practicability would differ, or could differ, considerably between a large company and a small company.
Yes.
I mean, the Factories Act, as has been pointed out, applies from everyone from a small family unit where you deem there to be employment, but there isn't employment, in fact, right up to the largest corporation.
Indeed.
And what might be reasonably foreseeable to one might not be reasonably foreseeable to the other.
Well, yes, except of course we say reasonable foresight's got nothing to do with Section 29 and the Factories
Well, that's a different
Act.
question.
But reasonable
I'm assuming that reasonably for whatever purpose.
Yes,
I
for
understand
the
you say
purposes
it's
of
irrelevant.
reasonably practicable, I'm not going to take time to argue that there couldn't be a difference in standard. But we say that the real distinction is between the material in the public domain and material in the private domain. That's really what the special knowledge category is. Yeah, and Mr. Huckle makes the point that any advisor, of course, would have access to all the public domain materials. So, my lords, can I just briefly show your lordships these cases where liability has been found below 90. And the first of them is Cropper, which is in the authorities at volume 2 at tab 31. Who is the judge? Who is the judge? This is a county court case. His Honour Judge Duncan. The judgment is signed, in fact, on the last page in November 1992.
So are we looking at this to identify some proposition of law, or what?
We're looking at it to see what it was that allowed liability to found at the level of 85, and I'm essentially going to show your lordships that it was material in the public domain that did that. So perhaps I should just leave it to your lordships to look at this in view of the constraints of time.
This is the one that
just
Dr.
take a moment,
Hickish
Lord.
appeared in.
So sorry.
One that Dr. Hickish appeared in.
Yes. Lords, can I just take your Lordship through it very quickly then? Lords, at page 2, your Lordships will see halfway down the big paragraph that the plaintiff's pleaded case was alleging that any noise level above 85 decibels was excessive. And at page 17, the cases are set out. The plaintiff's case, 87 to 88, defendant's case is that they complied with published guidelines set out in authoritative publications available to the industry, acting in accordance with generally accepted industrial practice at the time. While there may well be a residual risk to hearing at 87 to 88, the law doesn't require an employer to create a no-risk situation. Residual risk so small would have been unreasonable to expect the defendants to take steps to reduce it or seek to eliminate it. Published guidelines and authoritative literature on which the defendants rely, product of various researches, 50s and 60s, culminating with noise in the worker, and then there's reference to the code of practice, and at the end of that paragraph, on page 18, defendants submit duty the workforce was discharged once the workforce was operating at LEQ levels below 90 dBA. Although we see in the next paragraph that they conceded that there was a residual risk. What did the defendants know of that risk and how large a risk was it? 1964, they employed Dr. Hickish as their industrial hygiene specialist, and then his review, his evidence of the public documents available to him run through to page 23, where your Lordship will see 5 lines down, Hickish states that the turning point in the development of assessment of exposure to noise came in 1970 with the publication of the research work Burns and Robinson, which showed that hearing damage may be related to total noise dose. Well, then at page 30, at the bottom of page 30, Zona says, I'm satisfied from what Hickish told me and from Mr. Hughes, that's the defendant's engineer, from various publications research he has referred to, employers such as Ford's knew or ought to have known that 10% of their employees might be at risk if exposed to levels above 85 dBA LEQ. They knew or ought to have known that there was no magic safe level at 90. Coming to this conclusion, I place no reliance at all on the Ford documents referred to by the plaintiff's engineer. And then at page 35, the last paragraph on the page, Hughes and Hickish pressed as to what could and should have been done by the defence to protect the susceptible, i.e. the 10% of the workforce at risk, levels under 90, accepted by 1970. It was well known there was a percentage of the workforce susceptible, stated ideally everyone exposed to levels above 85 should be offered protection to reduce their exposure. Asked, therefore, what a reasonably prudent employer should do when he knew or ought to have known there was about 10% of his workforce susceptible at noise levels below 90. Hughes said the workforce should have been given protection in those circumstances, but he believed that employers were not told this.
I'm not sure what we're getting out of this. Right.
Lord, simply the basis on which liability has been founded in the past. Well, Lord, I'm not sure I need to...
Dr. Hickish, he was employed by whom?
He was employed by Ford.
By the defendants?
Lord, but he sat on the committee.
Give us the cases where you say liability has been found.
I will, my Lord. Apart from Cropper, the next one is Howells and British Leyland, which is volume 3 of the authorities, tab 57, and the relevant paragraphs are 2, and 21 to 27.
Sorry,
Or
would you
maybe
say,
pages, in fact.
sorry, would you say that again? I'm terribly
I'm
sorry.
so sorry,
My
Bob.
fault.
Howells and British Leyland,
Yeah.
Volume 3 of the Authorities, tab 57, pages 2 and 21 to 27, and Harris and British Railways Board, Volume 3, tab 52, pages 10 to 11 and 37 to 58. I think those are paragraphs, actually.
Well, I don't know whether Dr. Higgins's case is relevant, but it is of interest because it's the very issue which is debated in this case. Almost it's the very issue which is
Yes.
we're being asked to consider.
Absolutely, my Lord. So those were cases where those employers had actual knowledge from material in the public domain, and that founded liability below 90 dBA LEPD. They don't support the appellant's contentions that the only way to establish liability below 90 is to show greater than average knowledge, in our respectful submission.
Who decided Howells and those two cases?
Judge Michael Evans in Swansea, that was County Court.
Yes, I think they're all county court level, my lord.
Well, Harris is not.
Harris's Court of Appeal, my lord. So, I'm so sorry.
That's where we started.
It was.
So do they grapple with this very issue?
They grapple with some of the issues, but not all of the ones in our case. Harris is the case where Lord Justice Newberger, as he then was, laid down a rule of thumb, or employer has to show why not liable over 90, an employee to show if under.
I thought it was 85, not 90.
90, yes. He found liability below 90, Lord, but that rule of thumb, it's paragraph 41. Good work, maybe a good working approach is a 90 gives rise to a presumption of sound. Above that level, only shift to the employer to show why it shouldn't be in principle held to be negligent, whereas if it's below that level, for the employer to show why duty should be opposed at all. Would not wish to be interpreted as laying down any rule or principle. At best, what I have in mind is a rule of thumb. But I'm proceeding very much on the basis of the evidence and the arguments developed before us. And in the paragraphs that follow through to 58, in particular 53, he says, first it appears to me clear that from 73 at the latest, defendant well aware of the fact exposure to a level above 85 gave rise to a real as opposed to a minimal risk of damage. And at 56, he says, all in all, appears to me relevant employees appreciated the risk to employees of exposure to noise at over 85, believe that limiting the volume of sound to that level was feasible, well aware that this could be achieved with ear protection, possible difficulties involved in providing employees with ear protection shouldn't prove insurmountable. And at 58, right to mention that connection with claims against other companies, judge's decision on this point doesn't stand alone. We can refer to a number of first instance decisions where the same conclusion was reached. However, in fairness to the defendant, any other employers against whom such claims were brought also right to emphasise that it's inevitable that each case turns on its primary facts and particular inferences, whether agreed between the parties or found by the court, documentary evidence put before the court. So, analysing that case, we say that the information did in fact come from the public domain, but the disclosure of the British Railways Board showed that they were well aware of it and had taken it into account, although they didn't act on it sufficiently.
It's a rather curious case because the British Railways Board actually required employees working in the cab not to use ear protectors.
Yes.
So, in a sense, they went beyond doing nothing. They positively interfered with the possibility that employees might protect themselves.
Oh, yes. Lord, so far as the knowledge of the particular appellants in this case, and I've dealt with this, and it might be a convenient moment to your lordships, can I just have a look at what the judge found? So far, taking the defendants one by one in the judgment, I'll take for convenience, if I may, the second appellant first, that's Courtaulds. Courtaulds are dealt with by the judge at paragraph 50 and following. And paragraph 51 is on a records that the main evidence was given by Dr. Peter Cooper, who was responsible from the 1980s. He said, in the fourth line of paragraph 51, that it was in the early 1980s the issue of noise in industry began to be widely discussed, not involved with noise until the end of 1982 when he was asked to form and chair what became a noise committee. No direct evidence of what happened before that time. And then there's reference to claims for damages for industrial deafness coming through, 200 pending by 1983. One difficulty in defending them was that there had not been the systematic noise surveys that the 1972 guidelines required. And then over the page, paragraph 52, Noise Committee first met on the 17th of March 1983, and picking up the last few lines of that paragraph, and he says, by the March 1984 meeting, in nearly all factories over 90 and between 85 and 90 had been identified. The policy was to mark and achieve compliance. The compulsory over 90 areas, then designate 85 to 90 as recommended areas for protection. 90 action was immediate, 85, 90 areas rather more medium term, suggested 75% acceptance of hearing protection in recommended areas should be the aim for mid-1985. Then in paragraph 53, by the end of 1985, 100% compliance had not yet been achieved. And at the foot of the page, above references indicate that by 1984 in the Courtaulds Consumer Products Group there was a policy or intended policy of making hearing protection available to employees exposed in the 85 to 90 range. Need for information and encouragement was also recognised. And that paragraph concludes by saying that Dr. Cooper, however, understood that there would be some people exposed below 90 dBA LEQ who would suffer damage, and we take that to be a reference to the early 1980s, which appears two lines earlier on. And then in fact 54 it says, concurrently with the beginning of Cooper's involvement in early 1983, Courtaulds active in the debate stimulated by the 1981 consultation and the EEC draft directive. And it gives the number of employees who would be affected at 85 dBA and above. And then the conclusion really is paragraph 56. There's no doubt that Courtaulds had the resources to look beyond the 1972 guidelines, reach their own conclusion about the nature and extent of the risks posed to the hearing of their employees exposed below 90. Doesn't draw any direct inference. in the fact that a witness was not called, and picking up the last 8 lines of the paragraph, which the Lordships, I think, saw this morning, clear awareness by the 1980s that exposure to levels of noise between 85 and 90 could be expected to damage the hearing of some workers to the extent that action was desirable at those levels. No large company had responded to the consultation document, read the background, aware of the proposals, and one that then took part in the debates to fend off compulsory protection at 85 on economic grounds, but not on grounds that such levels of exposure not harmful, could be said to be ignorant of the facts by the beginning of 1983 at the latest, and the facts referred to are plainly that exposure between 85 and 90 could be expected to damage the hearing of some workers. So that's the basis of knowledge for the second appellant.
Would that be a convenient?
It would be.
10:30.